Hi, I'm Shelley Hughes, Senator for District M in Alaska, and I am doing a clip today to bring you all up to speed on something that impacts about 20% of our students across the state. It is what is before our courts regarding our public correspondence homeschool program that is funded through the state of Alaska and allows allotments to be used by parents for the child's educational purposes. And that has been questioned if it is being used at a private and or religious institution. So Judge Zeman ruled that it was unconstitutional, along with pretty much striking down the homeschool program, including the individual learning program plans for the students. And there was a stay put on it so that the correspondence program could continue in place till July 1st of this year. So now the state has appealed the judge's ruling, and it is before our Alaska Supreme Court. So I wanted to bring you up to speed. The state is being represented by First Liberty Institute, which is a law firm that has dealt with this issue in other states and is being represented with an attorney who is the former Solicitor General from West Virginia, I believe, Albert Lynn. So that the hearing is happening this week. Because of the July 1st cutoff date, as far as the extension ending, I expect the Alaska Supreme Court justices to rule fairly quickly. And I'm making this clip because I want you to become aware of what our framers in our Constitution intended when they wrote the key line, which I will read in a minute. But I'm also hoping the Supreme Court justices will take the time to read the 21 pages of the Constitutional Convention that pertain to this very sentence upon which they will be deliberating, because these 21 pages answer the questions that are at stake. And I would go so far as to say that Judge Zeman in the lower court, the Superior Court, if he were a physician, I would say he performed some malpractice. Because reading this, there's absolutely no question in my mind that our framers did not intend for public funds to never go to a private institution if it benefited the child. It was very, very clear as they debated back and forth the worst use of the word direct benefit versus indirect benefit, what they intended. So I'm going to read the line of the Constitution that is at stake here is the core of the issue. And that line is from Article 7 of our Alaska State Constitution, Section 1, and it's the final sentence. It says, "No money shall be paid from public funds for the direct benefit of any religious or other private educational institution." Okay, read it again. "No money shall be paid from public funds for the direct benefit of any religious or other private educational institutions." So what did the framers discuss in regard to this? They were debating whether any penny should ever go, and there was an amendment actually by Delegate Jack Coghill to add the word indirect. So they really talked about direct and indirect. And this is what they concluded. This is how, if you read the various comments, what the word direct benefit referred to. So I'm going to read that first. So let me find, I'm going to be leafing through here a bit. By the way, it's 21 pages, page 1509 to page 1530. And on page 1534, the discussion, and I'm going to skip a few insignificant words, but I am going to be reading. You can see my highlights here. Did I just do it outside the camera? But this was a comment made by Delegate Armstrong on the word direct. And he was on the committee that worked on this. And he says, "We have used the word direct. It was spelled out that this," and he's referring to what direct means. "It was spelled out that the maintenance and operation or other features of direct help would be prohibited. This was not intended and does not prohibit the contracting or giving of services to the individual child for that child benefits as his part of society. This gives the education department or other departments the right to seek out the child to help him to become a strong and useful part of society. I'm trying to see what else here that I want to bring to your attention. We did this to take any doubt away on the part of this convention of our motives. We do not wish to interfere with the practice of helping to serve people through these institutions, okay? So now, the direct benefit, I want to read, that was further discussed by Delegate Armstrong later in the debate as he described what this word direct benefit would mean. This word direct benefit, this would prohibit the direct appropriation for building or maintenance of a private institution. In other words, an appropriation of public funds to for the sake of a private institution's assets, their building, maintaining that building, making sure there was heat in the building so the pipes don't explode, the asset, that was prohibited. Now, what was allowed? What was considered okay as the delegates discussed it? What was considered okay? I'll just tell you and then I'll read some clips. Providing through a private institution hot lunches for students, bus transportation for students. And actually, this one is pretty key. It was right toward the end of the debate. It was Delegate Kilcher. Delegate Kilcher brought up right before they wrapped up and before the vote, the roll call and the vote. He basically says he was a father of 7 children, 5 which were attending the Calvert course. Now, the Calvert course, if you research it, is a program. It focused on core subjects such as math, science, history, and language arts, but it also offered a course such as Christian faith and living course. Okay, so this had a faith-based element. He indicated that 5 of his 7 children were attending the Calvert course for several years. And he says, I understand that the Calvert course would possibly construed not to be available anymore either if indirect help were not available to a private school. The territory pays it. There was a territory at the time. My children go to a private school. The biggest ones, though, hike over the road, and the territory pays an indirect system. So they were paying to go to the Calvert course, which was a school where they had to hike, okay? So when he brings that up, what is the response? The response is by Delegate Jack Coghill. He was familiar with the Calvert course, and he said because it was a recognized correspondence through the state, well, at the time, the Territorial Department of Education, I want to read that correctly, it would be fine. So here we are, again, funds that would benefit students who are attending a private school that actually even had a faith-based element. I believe the Calvert course now is very much, is no longer has that faith-based element, but at the time, in the earlier years, it did. I want to read to you just some of the items because one of the conversations was that we don't want to deteriorate our public school systems, and they were referring to tax dollars in Europe going to many private religious schools. And so the case was being made that we need to, at this point, it was Delegate Coghill actually. He wanted to kind of have it even be more broad and was trying to add direct and indirect. And he was saying we need to do this so some of the tax dollars don't go to private schools. And his amendment actually failed. He, even after he gave the example of Europe, where some of the funding was going to private schools, a constitutional body rejected that. So they obviously did not agree that they didn't want a penny going to indirectly going to a private school because the indirect could reach into infinity. It would shut out certain things that should not be prohibited. For instance, care for the children that would be administered through the schools. So they did indeed. Here's another interesting conversation that Delegate Smith brought up regarding the superintendent of schools at the time in Ketchikan, who initially wanted to keep any funds from going to public schools, but then realized that their hope was that the parochial schools would have standards equal to that of the public schools. And if that were to happen, that would require some involvement of the Board of Education, which would require then public funds. So the superintendent of Ketchikan agreed he did not want the word indirect inserted. I'm reading that directly from here. Because he wanted that flexibility. Here we have conversation about hot lunches. I'm trying to see what else might be helpful to you all. If I want to read this one that states that the reason they did not want to include the word indirect and indirect because they felt it was so far-reaching and that it would prevent services to children that attended these schools. So clearly, if you're leaving out the word indirect, that means they did want some indirect benefit to go to the schools by allowing services and things that would actually help the individual child. And I also wanted to mention on, I can't quite see this page number, page 1523, there was actually at the time a letter written in the territory, a number of schools, I'll read this, a number of schools operated by private and religious organizations to which the territory now pays funds through the department, in this case, public welfare. They show, I think they perhaps were referring to orphans and foster children. They show that such institutions not only include a few Catholic institutions, but also Seventh-day Adventist, Moravian, and Presbyterian, and these were also offering schooling. So these payments were made to these various children institutions that were private and in some cases had a faith-based component. So I want to wrap up by mentioning that by including the word indirect, trying to eliminate even a penny, anything going to the schools. What delegate was this? Buckaloo. And this is on page 1524, said, if we include the word indirect, here is his quote, it would eliminate the state giving any support to the child because that would be indirect support to the institution. If members vote to include the word indirect, is what he was saying, here's the quote, they ought to understand that the word indirect cuts out everything. It eliminates all kinds of support. And so how did the vote go? They voted against adding the word indirect because they did want things that would benefit the individual child, the individual student to be allowed. So I just think that these minutes are crucial to understanding this issue, and I hope the Supreme Court justices will consider what our framers intended. It wasn't that there wouldn't a private institution couldn't receive an indirect benefit. It's all about the child. It's all about the students. So I want you to know what our framers decide, how they deliberated on this issue, and I hope that our Supreme Court justices will also consider this. I don't know what the state is going to present through the First Liberty Institute as far as whether they even bring up these minutes, but I would say for a Supreme Court justice to do his or her job correctly and thoroughly, these minutes need to be read. And I think in reading them, we will understand that something that is of benefit to the child is okay. And actually, based on the one delegate, 7 children, 5 of which were attending a private school, Calvert School, which at the time had a faith-based component, that was allowable and considered an indirect benefit to the child. So with that, I wanted to close this out. We'll be looking forward to how the justices rule, and we wish the state well, because we think this program is one that should continue and be strong. It's so important to so many families. So just want to give you that update. Thank you very much.